All right, let's go ahead and get started. So, we have moved into defenses, our fourth of 5 categories for this class. That is, we have hit the point where a contract has been formed, it has been sufficiently formalized such that it is enforceable. We know what the terms that are written in it say, and we have something to say about what the terms that aren't written in it say. And now we're moving to, fine, if all that's true, under what circumstances could a court say, yeah, you have a fully formed and enforceable contract, and I know what the words mean. We're just not going to do that. And that's where we are in the class. Now, administrivia-wise, I'm not aware of anything in particular. I'll try to take questions after class today because I know we didn't have that opportunity due to a meeting that I had for the faculty on Monday. I'll do my best to try to take questions quickly. I do teach AI this evening though, so at some point I'm going to have to go prepare that. Otherwise, we have the double up meeting on the 27th. We're going to go 10 to 12. We're going to go 10 to 12 on that because 9 to 11 is rough if there's not a reason for it. I don't want to get you up out of bed like that early that morning. So let me know if there's some reason that doesn't work. That's all the administrivia. I've got any administrivia from you all before we get going. All right, cool. Then moving on to that. I'm just going to recap where we are in defenses. We'll then take any questions you have before I pick up again with Ben, and I'll assign co-counsel for each of the cases today. These are longer, harder, more complicated cases, and so we'll need sort of the back and forth that we get instead of kind of the one-person presentation that we've been doing to date. All right, so on that note, what we've been doing is defenses, and we've started with both the easiest and the most difficult defenses. But I have to say, although we're talking about the defense of public policy and illegality, you can really just boil this down to there are two very specific defenses where if you say this contract will not be enforced on grounds of public policy, the court will not just snort at you. This is normally an extraordinarily weak thing to say as a matter of law. It's a very strong thing to say as a matter of framing up the question of the case, but this is very much an area of law that we do by giving the court wind beneath their wings. We do not do it by saying the law requires you, Your Honor, not to enforce a contract because I'm in my feelings about it. That's not why we refuse to enforce contracts. And I think you can see, contract law is a law of absolute liability. The supposed saving grace of the whole thing is that everyone has agreed to it. And under those circumstances, I understand that's not actually our lived experience of contracting, right? But that's the theory. And if you've agreed to it and it wouldn't have applied to you if it didn't, it's going to be a really hard thing to tell a court, yeah, look, just don't enforce this thing that I agreed to just because now it's not working out in a way that makes me happy inside. It's a real hard one to do. So better than understanding these defenses as we do not enforce contracts that violate public policy, although that's what the restatement says, and that's what the courts and that's what the cases say. That's not really what's going on here. Really what's going on is that we're beginning with 2, and we will expand to a number of more reasons where the court's going to say, it's not just public policy as a weak argument. These are defined areas where courts are going to use public policy to fix a real problem in contracting. We saw the first one, that was illegality, in which, of course, courts are going to say A and B can't enter into a contract to commit murder against C. That's not fair to C. None of our intuitions about contract law really enter into the picture. But we can do, contracting around murder, we can't do that, right? But, we can, as long as it's just the people parties to the contract, we can contract around a little light assault and battery, for example, right? Boxing? Surrounded by contracts, right? Only not a tort. Right? Their job is attempted murder. Only the fact that there's some sense of consent and that's got contracts all around it prevents that from being a tort at best and a crime at worst. What makes it work? The parties who are involved are parties to the contract. And so when we say, it is true that as we saw in Klaus versus Myers, there the parties did have, they did have this contract. It was just between them. And you might ask yourself, well, how's that not like the boxing analogy, right? If I decide I want to buy your bar without the proper licensing, and if you decide you want to sell your bar without the proper licensing, and we're going to just engage in this shenanigan whereby as I buy the bar, I'm operating under your license and I don't get a separate liquor license, why not let them do that? And the answer, it should be obvious at this point, is because the licensing scheme is not to protect the parties to the contract. The licensing, it's not their right to give up. The licensing scheme is there to protect the patrons of the bar and anyone else in our state who does or does not have access to alcohol in ways that the jurisdiction has decided, right? And so we just don't get to change those rules. We get to change a lot of legal rules about us when they impact us, but we can sign away a lot of our legal rights, but we can't sign away other people's legal rights. And so that's why the public policy really boils down to illegality. Now that's one area where public policy suddenly gets real teeth. It moves from being this very weak category to a strong one. We're going to pick up with, and our big mystery, I'll sort of start with Ben and then assign opposing counsel. The big mystery of cases like Allpets and Hopper is, why is the court doing it there? Illegality, I think we see. The question is, why is it doing it there? And that's where we'll start. Before we start, though, you've had a minute to warm up your brains. Do you have any questions about anything in the class up till this point? We'll just go over them real briefly and move on. Chris?
So on an exam, public policy is like cherry on top. You don't want to leave with that. And that's not really a remedy, but illegality we can't hit on the main meat of our argument, correct?
That is correct. That is to say, if you want to make a legal argument, you would say, maybe even if you wanted to really blow me away, say, although public policy generally is a losing argument, illegality, contracts in restraint of trade, and unconscionable contracts are exceptions under the law. Here we see this contract is going to be deemed void for violating public policy because it is a contract in restraint of trade, or because it is an illegal contract, or because it meets the standards for old or new unconscionability. Those are the major defenses that we're going to be moving through. So you just identify, or if you want to move just faster, just stick with the legal arguments. The contract is void because it's in restraint of trade. Liam.
Would collusion or conspiracy be another one of those illegality things, or is that a different silo?
It is, although it's one of these places where it makes it really complicated, right? So this is, one of my favorite quotes, by the way, in criminal law was, if you ever wish to be truly terrified about the state of American law, go take a look at the substantive law of conspiracy. A conspiracy has been so broadly expanded, it can capture all kinds of behavior. My personal favorite was one that was based on, to the best of my knowledge, on an event that happened about 5 blocks from where I went to law school, in which there were people who were on opposing sides of a criminal confrontation. There was a police officer who was following one car full of people. That car realized they were being followed, so they stopped in front of their enemies, and that provoked a gunfight. And the people involved in the car escaped as part of the ensuing gunfight. The police officer, I believe, was injured. Here's the important part. Everyone involved, both sets of enemies, were deemed to be conspiring with each other to reach this result. That's how broad conspiracy is. Well, look, if that's true, then almost everything, like we are right now engaged in a conspiracy to get money away from our clients. Like if you chose to push it, that's just how broad and vague and terrifying the law is in that particular area. And I think I referenced this in last class too, right? Like, is just the use of AI some kind of Sherman Act violation where we're like gonna move through and say you are using it to set prices, therefore you're coordinating your activity with mine. It's a very, very broad category. We're looking for really specifically, obviously illegal stuff. Arguably illegal? Sure, but at that point it really starts to be, like, are all of every contract ever by most major multinational corporations void for illegality because that company is doing, like, they're all doing something illegal somewhere. Are they void? Like, probably not. Do you see what I'm saying? Again, we get back into the fuzziness of public policy, and we do not want that stuff running around loose. And so we're just going to say, like, unless it's, in my personal experience, unless it is obvious illegality for the act involved in the contract itself, not for, like, what the contract means, we're probably not going to touch it. It's a great question. Yeah. Absolutely. Glad to do it. How does the Weintraub case fit into the cheapest cost avoider? All right, so first of all, let's just do a reminder of what Weintraub is doing in the course, right? It is, Weintraub is a defense under Restatement 164. The idea is that the contract, although it has been properly formed, and it looks like everybody agrees, because consent to the contract was procured by misrepresentation, we will not enforce it. All right. Then I have two things to say about that. First is, look, y'all, this is Liam's question all over again, right? Every contract you could make, seriously, when you go into practice, you will be able to say, and your client will swear to it in court, that the other side misrepresented something about the contract. They're just going to do that. Among other things, because the price of something is either going to be more or less than somebody thought, which means somebody's going to be sad, which means somebody's going to say things like, the other side didn't tell me that it was going to be worth less than I thought it was. Now, they don't say it like that because that makes it a little too obvious. What they'll say is, they didn't tell me something about it, like cockroaches, that made it worth less than I thought it was. But it's the same thing across the board. And so we have to be really careful. The general rule in practice, you will find almost every contracts dispute will have a claim in it for fraud, and it'll have a claim in it for misrepresentation. And because misrepresentation is a tort too, right? You get two bites at that apple, and so it goes into almost all of these things, and courts almost always ignore the fraud count and the misrepresentation count. And I need you to see that that's because every contractual dispute that falls apart, they're going to be like, they lied to me. About what? About how valuable this contract was going to be. No shit, that's what contracting is. Hi, you lost your bet against the universe. Shut up, sit down, right? But those things are all in there. So when you look at 164, again with Liam, like, don't take it too seriously. Right? Bear down on the specific sets of circumstances that are going to make the court go, oh, this is actually when I'm going to pull out my tool that I was given and actually use it to deal with the problem. All right. So when is a court going to use 164 misrepresentation? This is one of the specific examples, although you can say misrepresentation in every contracts case. The sale of residential real estate is one of the narrow places where it actually gets teeth. And that's because of your question, because courts have a strong sense that when we're dealing with residential real estate, the seller is held to have known a lot more about the property than the buyer knows. When residential real estate goes through, the buyer is often deemed to not really know all that much about the field or the business because they're buying it to live in, they're not buying it as an investment. Ask me how Weintraub versus Krobach goes if the buyer was buying it as an investment property. Doesn't go this way, I'll tell you that. Like, oh, the thing I bought was worth less than I thought it was when I had every opportunity to inspect it, and the other party told me that they were selling it with all faults as is. No, you are not undoing that contract. See how clear I am on that if you offer to buy my car. Right? So we have to figure out why the court would do this, and the answer is because in residential real estate, the seller knows so much, and the buyer knows so little. And generally, the buyers are not sophisticated counterparties. They're looking for a place to live. And the stakes are so high. And does it help that we're mostly dealing with like rats and cockroaches? Like, yeah, that matters. That matters a lot in terms of letting people off the hook. And we saw in the other case, right, where it was the sewer system that they weren't told about. The court's like, it sucks to be you. You bought it, right? So it's just a completely different outcome there. Okay. As an economic matter, many judges who are into resolving not just the cases, but the costs of future cases are going to do something like Posner did in Colfax, or like the judge does in Weintraub, which is to say, let's look at the party who knew that there was a problem there and put the burden on them to say something about it. Because if they don't, then it becomes my problem, and that costs us in litigation, and that costs us in confusion, and that costs us. So it's a way of resolving these questions. But even saying the cheapest cost avoider doesn't solve the fundamental problem of when we apply Restatement 164 misrepresentation, because again, I will drive you to my core example. There is one thing that everyone does know about their interest in a transaction, and it's a fact, and the other party doesn't know it, and the other party wants to know it, and it is material that the other party do know it, and there is not a snowball's chance in hell that a court will ever make the party that knows it disclose it, and that's your reservation price for the good, for the asset, right? Like how much you would really pay for it in a pinch. No court will ever make you disclose that. So all of the language that we see in Weintraub versus Krobach, like there, I am the cheapest cost avoider of my own reservation price. Like I'm the one that knows it. I'm the only one that can disclose it. There's no way you can know, right? It's important to you to know. I am the cheapest cost avoider. And even the language of Weintraub would seem like, okay, this is important for the other party to know. We can go down the list of features that the court said. And we still wouldn't apply it in this case. So you do need to look at the broader broader context of 164 before you just trot out and say, oh, misrepresentation. Because there are misrepresentations and then there are misrepresentations, right? And the court's not going to treat, they told me something about, they didn't tell me something about this thing that I bought and now it's worth less than I thought. Like that is not an argument that generally goes anywhere in a contracts class. And so we have to figure out why in this very specific case, what cheapest cost avoider was doing. Sure, it resolved the problem, but that just begs the question, why are they trying to solve that problem when there's so many other things that I know when I go to buy my house? I suppose I never finished that story. I never knew why we got the house that we got for so cheap. I had no idea. No idea. It turns out it's a tragic story. It turns out that the people who lived there had a son, and that son was killed in a tragic accident, and that it turns out that it was my kids. Like they wanted a young family to be in their house. No idea. Imagine a court requiring them to disclose that, right? Just not a snowball's chance in hell. So we can't take Weintraub too seriously. Or if we do, because it's a legal argument, but if we do, we better know that it's in the right context. And the context of that is sale of residential real estate where the party has actively concealed the fact. That's the specific thing they're looking for on the bar exam.
Like in a single sentence, like how does that connect to cheapest cost avoider?
Cheapest cost avoider avoids the problem next time around when one party knows something and the court's like, the way to resolve this is to have the parties disclose it. If the courts have the parties disclose it, then it's obviously cheaper to put that burden on the person who knows the thing rather than the other person.
Can you please re-explain the three-step process to sue under the Magnuson-Moss Warranty Act for implied or express warranties?
You got it. Now, it's not a three-step process. It's a guide through the statute. All right? Here are the relevant parts of that guide through the statute, Magnuson-Moss. The first is, why are you able to sue? Because Magnuson-Moss, section 2310D, 2310D, I should also add, sometimes in some horn books, you will see that as like section 110 of the Act. 2310 is how it's instantiated in the code. So that's the language I'll use, but it's the same. 110D, if you see that in a horn book, is the same as 2310D. All right. So section 2310D of the Act says, a person who gets their hands on a commercial good in the stream of commerce can sue the maker of a warranty or the seller for, 1, breach of the provisions of the Magnuson-Moss Warranty Act, or 2, an implied warranty. That's step one. Says you can sue. Step two, if you look at 2301, that's the definition sections of Magnuson Moss, there's a couple of things to notice. First is that a warrantor is the person who made the warranty, not the seller. And second of all, if you look at their definitions for who gets their hands on the goods, the recipient, that's anybody who gets their hands on it during the duration of a warranty, which is an abrogation of vertical privity. That is saying, if I buy something at a yard sale, if I buy something from you, and it is still under warranty, there is at least an argument under Magnuson Moss that I can sue the warrantor. We do not have privity of contract. Our names are not on the same contract. They sold it to A sold it to B sold it to a retailer, C sold it to D, I bought it at a yard sale from D, I'm E, right? No contract has both our names on it. But Magnuson Moss appears to move to our industrial economy idea, which is that if you make warranties and release goods into the stream of commerce, you can be sued on those warranties by the person who eventually gets their hands on the goods and is harmed by your good blowing up. All right. That part is the definitional section. That's why you do it. There's one additional element to 2301, and that's 2301(7), which defines implied warranties. Remember 2310D said you can sue on implied warranties. 2301(7) says, well, what's an implied warranty? It's 2314 and 2315. It is the implied warranties under state law. Now we're left with one last thing. So what we've now said is, as a matter of federal law, you can sue on a state law cause of action. And there's an argument, although notice that in Monarch, they didn't go for this argument, but there's at least an argument, and it works in many states, that you abrogate vertical privity when you do that. That you're able to, even though you didn't sign a contract with the manufacturer, you can directly sue the manufacturer, even if your state's Products Liability Act doesn't say you can. That's normally where you would go looking for it. You'd normally go looking for that vertical privity part in your state Product Liability Act. The reason that that is not on the bar exam, and it is only rarely on my exam, is because they have to give you the state's Product Liability Act, and then you're like, oh, well, this is the question you're clearly asking, right? So it's just a bit of a too flaggable question. But there's at least this argument that you can do that. Okay, now, what's the other component of it? The other component of it is 2308. This is the big provision. 2308 says the following thing, which is not just that you can sue on implied warranties, but also federal law is going to knock out a whole lot of the disclaimers of these warranties. That's 2316, our disclaimer section. They're going to knock out a whole lot of these disclaimers that otherwise would scare your clients off from suing, right? They're going to say, they'll flip it over, they'll be like, it says as is with all faults. I know what this means, I can't sue. Not under Magnuson Moss. Magnuson Moss helps you cut through those disclaimers like you've got a lightsaber. It is just going to go boom, straight through them. Here is how it works. Courts get confused. You will not go read it until you understand what I am about to say. What I am going to say is not the words of the statute, but it is how it works. You need to go read it until you figure out why it does this. Here's what 2308 does. It says, if you make a full warranty, and you have to say, and it has to say full warranty. If it doesn't say full warranty, it had better say limited warranty, because that is a violation of the Magnuson Moss Warranty Act. But if it says full warranty, then two things happen. One, you cannot disclaim the implied warranty of merchantability or fitness for a particular purpose. 2316 doesn't work. Full stop. It just doesn't work. And the second part of it is, you may also not limit the duration of 2314 and 2315. You may not limit the duration of the implied warranty of merchantability, and you may not limit the implied duration of fitness for a particular purpose. Here is the fact pattern you will see that tests this. I gave it to you last time. Somebody's going to give you a 90-day full warranty. It will be, your date given in the question will be more than 90 days. It'll be at 120 days or half a year or something, all right? And what they need you to understand is that the fact that they gave a full, and they will also disclaim all implied warranties, implied warranty of merchantability, implied warranty of fitness for a particular purpose. They will disclaim them all. And what you need to understand is, first of all, the fact of that full warranty, it's done now. It's 120 days. It's done. That 90-day full warranty is over. But the fact that they made a full warranty means what happens to their disclaimer? Leland? Doesn't work. And what happens if they tried to limit the duration? It doesn't work either, which means you can sue on 2314 merchantability or 2315 fitness. You can sue even though two things are true. You are out of the duration of your full warranty and they have disclaimed all the implied warranties. Can you see why they just cannot stop asking this question? Even though it's so rare because nobody ever uses full warranties, but they cannot stop asking this question because it's so clean and so testable. And it also takes an absolute loss for your client and turns it into like, oh yeah, I'm just absolutely going to sue and I'm going to win. Okay. The second thing that 2308 does is this. If you make a limited warranty, this one happens a lot in real life. Limited warranty. If you make a limited warranty, you may not disclaim the implied warranties of merchantability or fitness. The disclaimer doesn't work. But you may limit their duration to the duration of your limited warranty. So if you've got a 90-day limited warranty and you limit the duration of the implied warranty of merchantability to 90 days, and you limit the duration of the implied warranty of fitness for a particular purpose to 90 days, and it's 120 days later, then your client's going to lose on all fronts, right? Because they're out of warranty, they're out of the express warranty, but they're also out of the implied warranties because you can limit their duration. But if it's at 60 days, right? If you have a 90-day limited warranty, and they have disclaimed, they've said no implied warranty of merchantability, no implied warranty of fitness. I am disclaiming them. I've done it appropriately under 2316.2. They did everything right to get rid of merchantability. They need to say the word merchantability, which they do. They will say, we are disclaiming all warranties, including the implied warranty of merchantability and any warranty of fitness for a particular purpose. That's what they'll say. And then they'll put them in letters that are on the front of the document that are in glowing, flashing 1990s style internet font. Because they need it to be conspicuous, right? We did all that. They do everything right, and it doesn't work. All of the right things that they're doing don't have any effect because 2316 is removed by federal law 2308 when someone makes an express limited written warranty. An express limited written warranty. That's how it works. Nate.
This question about 2314 and 2315, do we need to like intimately understand the difference between each?
Oh, hell yes.
So like a car, for instance, right?
And 2313 to boot. You need to understand, this is one of our big knots in the class. Just like 2201, 2202, 2206, and 2207 are our formation and formalization knot of statutes. You absolutely need to understand that 2313, 2314, and 2315, and 2316 are a knot of statutes, and you need to know how each one of them works and how they interact with each other. You absolutely need to know that. It's one of the most important things. I don't think there's a single exam I've given, and I know there's no bar exam that's ever been given that doesn't include those sets of knots. Absolutely you need to know it.
So like a car, for instance.
Yes.
The standard merchantability is that the car runs, it's a car.
Mm-hmm.
The particular purpose is like it's a reliable car.
Yep.
So
And can those both pop up on the same facts? You better believe it. And if I say, is this a reliable car? Or I say, I need a reliable car, and the guy chooses it for me, add a third cause of action. There's breach. So far you've got breach of implied warranty of merchantability, breach of fitness, and an express warranty. Tell me why, Lucas. Why is that an express warranty?
Because you asked for a certain thing, he directed you to that thing, so it counts as an express warranty.
Let's be very, very clear. You're right, but this is getting to Nate's question of how we differentiate it. If I say I'm asking for a thing and they direct me to that thing, what fact pattern is the bar examiner or I absolutely queuing you up for? Is that a dangerous hand or dangerous hand? Particular purpose. They are queuing you up for the textbook, absolute black letter textbook fitness for a particular purpose. Lucas is right. This absolutely also creates a hidden 2-3-13 problem, and Carpenter, that the case we saw is exactly the case to show you that, but it's on different grounds. I asked for something that I have a particular purpose, and then the salesperson guides me to that thing, picks it out for me. That's literally what they have to do under 2-3-15. The salesperson has to know your particular need, and then they have to select it for you. That's 2-3-15, but those facts also give you 2-3-13, but I need you to describe it. This is still answering Nate's question. Do we need to know how these things work out differently? Describe it. How does 2-3-13 make what happened here an express warranty? Not an implied warranty of fitness, but the same fact. How do these same facts make it an express warranty? Yeah?
Because by directing you to that thing, it is, even if they don't explicitly say this will run exactly how you want it to, by directing you to it, they're saying this will meet the needs of what you need.
That is correct. They are confirming a specific and definite statement about the goods. Imagine that the guy said, this gets 50 miles a gallon. Can you see that? Clearly an express warranty. With me so far? Can you see how that's different from 2-3-15 implied warranty of fitness? Right? That is how they would signal to you, we are talking about an express warranty, not an implied warranty of fitness. Let's try two more fact patterns. Now let's try, I come in and I say, does this car get better than 50 miles a gallon? And the guy says, this is the car you want. See what's going on there?
Would it be no because it's a fact stated about the car, so therefore it's not an express warranty?
It's a fact stated about the car. Actually, that's what an express warranty is a fact sufficiently definite stated about the product, right? That's a fact sufficiently definite about the product. If it's vague, if it's mere puffery, right, then it might not be a definite fact. It might not be a definite fact. Now, reliable maybe starts getting into mere puffery, right? But what I need you to see is that if I say, I need a car that gives me more than 50 miles a gallon, and they say, you want this one, they've done two things. One, they've met the fact pattern of 2-3-15, which is the salesperson knows of your needs and picks it out for you. And the second thing they've done is you made a definite statement and they confirmed it, which is them making a definite statement about the car. And that's an express warranty. This goes to Nate's question. It goes to how important it is because, among other things, then we can tie all of these things together. And this I will do to you. You're going to tie it all together. And you're going to find that the implied warranty of fitness for a particular purpose was properly disclaimed because it was conspicuous, but they didn't say merchantability, so 2-3-16 didn't knock that one out. But oh look, then they disclaimed all of them using something different, and federal law won't let them disclaim it. And you have to realize each theory is differently, and usually the way I write it is 2 of the 3 theories won't work, but the third theory, if you see it, gets all the way through the gauntlet. That's how I craft these questions. So the answer to Nate's question is absolutely, and Lucas's insight holds up. Chris.
All right, guy goes into a golf club
Yep.
shop.
Yep.
And he's like, I need something that can make me drive 300 yards.
Yep. I don't play golf, so I don't know if that's a thing or not.
Okay, so that's that like.
Is that possible?
Yeah.
Okay. Seriously,
Possible, but it requires someone else.
Yeah, so like it's something like not attainable by the average person, and it's also reliant completely on the customer. How does that fit into like a warranty where you're asking the person that has knowledge of the clubs?
Yep.
This thing, like the club itself, is not really the value that gives you the long drive.
Yep. Then I think they would start saying, what is the context in which you're operating? The relevant question was, does it permit you to make a long drive? If a person had the skill, would it work? Obviously, they're not going to say for a 4-year-old. But yeah, I mean, it depends on exactly what they say. But generally speaking, the court would say, well, yeah, that is a sufficiently definite statement under 2-3-13. Or it meets the standard of an implied warranty of fitness under 2315 if I said that I needed to drive over 300 yards and they're like, this is the club that you need. They bring it out to you. They pick it out for you. But that's all going to be bound within the context of, your skill is going to drive this, so it would just have to make it possible, would be my understanding. Austin.
I have a question about the gas mileage
Yep.
fact pattern.
Yep.
So that just creates a warranty around the gas mileage.
Yes.
When you drive that car off the lot and it breaks down, you can't then reference the express warranty. Right. Because that only covers the gas mileage claim that you asked about.
That is correct before I get fancy on you. Now, let's get fancy. Is this express warranty? Because you've just made an express warranty, right? And obviously, the express warranty is not violated if something else goes wrong that is not in the express warranty, right? Cool. Is this express warranty oral or written?
Oral.
Oral. Then the answer to your question is we stay with the simple answer. It's an oral express warranty. What's your problem with that oral express warranty? Parole evidence rule. But if you can find some way of getting it past the parole evidence rule, it exists, except that it's going to only exist for the gas mileage and not for the powertrain or whatever, right? Cool. Let's say it's written. That express warranty on gas mileage is written. What does that do? And that gives a very different answer to your question.
I guess you could make the argument that you did not use a gallon of gas and it did not go the 50 miles, so therefore, but it breaking down, therefore did not get 50 miles a gallon.
Which is a great argument, but I'd do that for the oral side anyway, right? Like to say that the reason that it didn't go far enough was because of some problem, like let's say it broke down because of a problem with the gas mileage. That's not what I'm after. What is the difference between the written? You really can't disclaim the implied warranties, which do cover all kinds of things like the car breaks down on the road. Why? Why can't you disclaim the implied warranties of merchantability and fitness for a particular purpose once you have made an express written warranty, Mike?
Because under the Magnuson Moss Act, if you make a written warranty,
This is the sentence I just gave you, and here it is. This is why we have spent 37 minutes getting to this particular point, because it is important for your career. If they make, as many companies do make, an express limited warranty written, 2308 says they cannot disclaim the implied warranties of merchantability and fitness for a particular purpose. They will always try to disclaim the implied warranties of merchantability and fitness for a particular purpose because it might scare off consumers from suing or scare off lawyers that didn't come here to law school. But the answer is they can't do it, and that's that's the fact you need to know out of all of this. Because almost every product has some kind of express written warranty. Very limited, but some kind. And almost every product comes with a full disclaimer of all the implied warranties. Can you see if you didn't know this, there'd be no point in teaching you about implied warranties. They would never happen. They'd be like unicorns. They just wouldn't exist. This is why they exist. Exactly right. Yeah.
Is there a limit to how short the duration can be in a limited warranty?
Nope.
So you can make it like for the next 10 minutes?
Yep. As far as I know. It's a great question. Yeah, go for it.
I just couldn't write fast enough. Could you repeat the fact pattern? It's like if you'll get a full warranty for 90 days. It's like you said again.
Okay, so if you get a full warranty, remember full warranty doesn't mean unlimited in terms of time. No company wants to warrant its products for a decade. What they're talking about when they talk about a full warranty are the things that we did discuss in Monarch. That's 2304, which I did not mention in my workflow. And the reason I did not mention 2304 in my workflow is because nobody ever issues full warranties, and if you do, I will come to your law firm. Even though I think they're great for consumers, and I am very pro-consumer, still, as a lawyer, your job is to help your client armor up, and holy mackerel, do not do that. So that's in there, right? The reason that it shows up on the bar exam or on my exam, though, is because it creates a lovely testable question. So, if you make a full warranty and you put a limitation of time on it, that's all fine. The thing is, 2308, you may not disclaim the implied warranties of merchantability and fitness for a particular purpose. Now, that's the same as with a limited warranty, as Mike's just pointed out. But the second bit, you may not limit the duration of the implied warranty of merchantability and fitness for a particular purpose. And that's what creates that lovely little testable question. Does that make sense?
Yeah. Could you just repeat the actual testable question that you gave us?
Sure, like the actual question would be something like, you get a 90-day full warranty that the car gets 50 miles a gallon. That's pretty much exactly Austin's question, right? You get a written full warranty. And it has to be written. All this Magnuson-Moss stuff doesn't work for oral express warranties. It just works for written express warranties. And yes, there's some case law that deals with that, but come see me next year. That one does get complicated. I'm giving you the easy version for now. All right. So if they give you a 90-day, and it has to say full, 90-day full warranty to create this problem, then you just need to be aware that one, the implied warranties are still there, and two, that they are not limited in duration.
Would an advertisement count as an express warranty, and would that be written?
I mean, man, who freaking knows? Probably not in the sense that courts are going to start Easterbrooking a little bit and say the real warranty is the one that you receive after you bought the thing. But I'd take money to argue it all day long. I would just have to get Lefkowitz on them. I'd get my Lapin Stoll out.
Is there a duration on like oral warranties, or is it just like a reasonable time?
I was going to say, what do you think it is? And then you gave me the answer. Sweet. Well done. Yep. Well done. Any other questions, y'all? This is why we do what we do, to get bored down on it so you don't get confused. Oh, yeah, go for it, Scott.
So is there any way to exclude implied warranties at all under 2316 anymore? Like,
Yeah. Here's a main one. This is really important. What triggers Magnuson-Moss? And yes, there's litigation around this. See me next year. But what triggers Magnuson-Moss? An express written warranty. Is there anything that says that if I sell you my truck, I have to give you an express written warranty? No. Is there, even if I have a writing, do we need a writing for my truck? I love that, right? Because it depends on...
If it's over $500.
Right, and by the way, I am willing to entertain offers below $500. Should you be interested? You'd have to pay me to get it off my property, right? But yeah, but like if it's over $500, I do need a writing. So now we have a writing, but do I need to put any express warranties in there? No, if I want to make no warranties at all, how would I do that? As is, with all faults. Or I might say, seller makes no warranties, express or implied, including but not limited to any implied warranty of merchantability and any implied warranty of fitness for a particular purpose. And then I put that on the front of the document and I put it in glowing gold font that flashes like it's 1994. And then that's conspicuous and it's done everything right. And I had all three layers of it, the belt and suspenders. Fine. Do you see how that works? Because there was no express written warranty made, because I made no warranties. I made no warranties. Nothing in Magnuson-Moss says you have to give a warranty. So yeah, then 2316 works perfectly well to get rid of them. Cool. Love these questions. Real practical stuff. Also, I gotta say, go look at the prior exams based on what you just learned. There is no question I love to ask so much as that one. And if you haven't seen it about 1 billion times, go look at my sales exams. They're on file too. Don't look at most of the stuff, it'll make you sad inside. Go look at the short answer questions. You will see one of these every exam, and you will find them and just be able to work through them. All right, this whole fight of 2314, 2313, 14, 15, how they interact with 2316, and what Magnuson-Moss 2308 does about it. I've just said it fast. That thing is a question I just ask all the time. I know, I've seen me do it. Okay, cool. Any further questions? And bring one to me. Do one. Bring it to me. It'll be fantastic, clear practice, and you'll get very clear answers. All right, let's move on to these. We've got Hopper versus Alpet. So Ben, you and I were sort of picking up where we left off, and I had opened with a question, which is, why in the world would the court pick this fight as one where they're likely to go, where they're likely to say, yes, there's a fully formed contract, the parties have agreed, we know what the terms are, we know what they mean, but suddenly, boom, we're not gonna enforce it. And we changed it to, boom, they're not gonna enforce it, to, boom, they're gonna pull out their pen and modify it, which is also just crazy talk, right? Like, a remedy that we will see in the future is modification. Modification is a remedy to a contract. You can ask the court to rewrite the contract for you. Anybody want to guess how often a court's gonna do that for you? That is probably the least effective thing you can ever ask a court to do, because the court has no idea what the value of performance was to the parties. They already have this economic problem of interpersonal comparison of utility. They don't know what it was worth to you. They don't know what it was worth to me. All they know is that we agreed on it, and then you're asking the court to rewrite it based on a deal it can't have any visibility into? No, not gonna do it. The question is why they're gonna do it. Which side do you want? Do you want, I am pro modifying this contract, or I am anti modifying this contract?
I'll take anti.
Okay, you're going to take anti-modifying the contract. The contract should be written as standard. Megan, would you mind taking the pro position? And we'll open with you. Why should this contract clearly be modified beyond we don't enforce contracts that we don't like? No, Megan.
She is entitled to be able to use her knowledge and grow her practice. There is plenty of economic business in our area to be able to sustain both of our practices.
So she needs to be able to practice her profession. Perfect first answer, probably the most persuasive thing you can say in one of these cases. Once we break down, get past the black letter law, to say the person needs to be able to practice their profession. Megan, why? Let's build this out a little bit. Why is it that it's really important that a person be able to practice their profession?
Well, she has put a lot of time and energy into building her client base, and she's generating income for herself as well as for the.
I hope you're listening, Ben, because there's some ammo here. Oh, I'm just going to ask Ben to take this apart here in a minute. Keep going.
As well as for our community, so
Oh, I like the inclusiveness. Right? Our community.
it benefits the public when we have more providers in our area who can serve our small and
All true. Again, really powerful. What I want you to hear, though, is these arguments that Megan's making, and realize how this would have gone over in the whole rest of the course, right? Like we're talking about our community here. What class are we in? Contracts. Who's interested in the outcome of a contract? The parties. And every time we're like, for the community. You remember what Posner said in NIPSCO? For the community. And Posner was like, I think not. Right? Contracts aren't about the community. Megan's absolutely right. To be clear, we got to get to the root of why. All right. One final point. What would be the opposite? Like, let's say she couldn't practice her profession. What's that do?
I think it's honestly more fair if she can't practice.
Oh, so actually give you the other side. Strong work. But we're lawyers. We got to deal with what we're handed.
What would happen if she couldn't?
Yeah. Like if we went the other way, right? You're arguing that she should be able to practice, that we're gonna modify this, because Ben's arguing we're not gonna modify it.
If we couldn't modify it, then it restricts the growth
Yes.
of the industry in our area, and
Oh, perfect.
it kind of gives them a monopoly to Dr. Johnson.
Love it. Did you hear that shift in language? What language are we using now? growth, monopoly, economics, perfect shift, right? So we've got our community, we've got our public good, and then we've got our economic argument. And that, I'm going to come back to that one in a minute, because that, when we start getting to the black letter law here, that one starts to carry the day here. All right, Ben, she did give you a little, like she gave actually 3 damn near perfect answers, but let's sort of push back on this. What about this idea that she needs to be able to practice her profession, and why should this just not be modified?
She's more than welcome to practice it.
There we go. Oh, I love it.
The township.
Yeah, she can.
Yeah, I mean, there's a sentence somewhere in here where many of the clients at Allpet came from all over the county.
Yeah,
She could go 5 miles outside the city limits and
she can set up
have the
out.
same clientele.
Yeah, I'll set up out there. Brilliant. What the parties actually said in this in argument. If you go look at argument, you have a response to that? Where are you from?
Where am I from?
Yeah.
I'm from Wyoming.
Okay, great, cool. Then this is not an unfair question. Where are we in this case? Specifically, what city are we in?
We're still in Laramie, I think.
Yeah, we're in Laramie. Do you notice what's the name of the practice? All pet. Okay, all pet. Cool. Can she go out 5 miles outside of town and practice her profession? That's what opposing counsel just said.
No, absolutely not.
No, absolutely not. Why? What kind of practice does she have?
She has a small animal practice, and that's her specialty, and most of,
Small animal practice. The fact that she can be a vet to cows is a profoundly different kind of practice than a vet to cats, right? Can you see the back and forth here? I'm not saying anybody's right. What game are they playing here as they move back and forth? There it is. The definition of the relevant industry and practice. It's just another lever pull for that silo, right? It's just another lever pull to say, what does it mean to practice her profession? To say that someone who is a pet specialist could go be a horse doctor, and the difference between downtown Laramie and 5 miles outside of town of Laramie is startling for anybody who's done that, right? Those practices shift based on where. Want to push back on that? Or another sentence about why we actually need rules like this, or people like her are not going to be able to practice their profession.
I mean, there's plenty of money in the large animal.
Yeah, one, there's plenty of money. She could go do large animal. Also, we're dealing with this like after she's made a connection with all of your clients. Clients? In their clients, right? And defending their clients. Yeah. I mean, if you didn't have this in place, would she have a job? No. And just curious, how did she get good with cats?
Dr. Johnson.
Yeah, exactly, right? We brought her on is your argument. Spin that out.
Dr. Johnson trained her up. He offered her full-time employment. She came to Laramie after she got her degree with nothing but hopes and dreams.
I like it. I got a couple of hometown lawyers here. This is how this works. No, I'm not kidding at all. Pitch match, tone match your judge, right? Fit into the environment. You kidding me? Simple country lawyer is a trope because it works.
And hopes and dreams don't get you clients, right?
Yeah, hopes and dreams don't get you.
She had to work for Allpet. She built up her clientele. Her training practices were directly from Allpet. I'm sure her review practices at Gem City are also created from Allpet. So her entire business is predicated on Allpet.
So we've got an interest in maintaining our client list, right? We were the ones that provided the training. We were the ones that made you good at this, and we wouldn't have been willing to do it if we knew that you were going to come in and steal all our clients. Got a response to that?
It may have been Mr. Johnson's clinic where all of this was taking place, but I think that Ms. Hopper was the one whose interpersonal skills and skills actually in the room with the clients built that client base, and there's no reason why those clients wouldn't want to follow her to to a different place. She's not requiring the clients to follow her, but she is, her skills as a veterinarian don't belong to Dr. Johnson, and so if the clients choose to come with her, this is what commerce is about. It's about clients being able to choose where they want to go.
Right, and we call that free market. Competition, right? Like, I mean, run the flag up the flagpole and salute capitalism, right? This is competition, right? This is competition. You want to be careful though. Do you notice the strategic mistake that was being made there?
She said it was just her skills that were being transferred.
Yeah. Yeah, what was actually transferred that your clients actually frosted about? The client list, right? So there is this idea that we're going to open up to competition, but we don't think that we're fostering competition if one business is stealing the trade secrets of another. I can steal your customers all day long, right? But I can't steal your client lists. I can't hijack them from your business because I'm sitting inside your business. But notice that sort of halfway through, what I loved was you were switching it because I think you were feeling what he was going to come back with, and so you were switching it from, I own these clients, they can just come with me, to general competition. We need to foster competition and commerce within society generally. Okay. And that's more or less where this lands. I mean, we've heard really strong lawyering of a pretty difficult case on both sides here. The thing I want you to see is what argument wins out, and this now is our restatement where is this thing here? Restatement 185, 86, 87, and 88, which is the black letter law here. How does that, and I'll just open this up to anybody, how do those restatement provisions really drive Megan's position prevailing here? Yeah, Fletcher.
Well, in the book it said that, and it cited the restatement on this, it said that the non-compete would be voidable if it was unreasonably in restraint of trade, and be unreasonably in restraint of trade if it was greater than needed to protect the legitimate interest.
Okay, there it is. Bullseye. We are not just talking about contracts that hurt our feelings. We are talking about contracts in restraint of trade. That's our category. Previously, we said contracts that are illegal, we will not enforce. Now we are saying contracts that restrain trade are not enforceable. And we're going to try to give everybody their best crack at protecting the business's needs, but also this whole area of law is subject to scrutiny that is not subject to in any other way. And I got a pretty nasty way of demonstrating to you how important this particular rule is for contract law. Now let me drive home the obvious point. That is the black letter law. Go look at the rule of reason. That's called the rule of reason in 188. The rule of reason is a specific limitation on contracts in restraint of trade, saying that they cannot restrain trade more than is absolutely necessary in order to restrict this. And that's why we get this Solomonic decision where neither party wins and neither party loses, but the court does do the extraordinary thing of taking out its pen and rewriting that 3-year term down to a 1-year term. And there's something else interesting about that 1-year term. It's already over by the time of this litigation. Right? So the court is basically like, yeah, no, I get it. Like I have to give lip service to enforcing this contract, but really screw you. And basically writes its remedy in a way that doesn't do all pet any good at all. Let's nail down that. Let's nail down why are we taking restraint of trade as being right up there with murder in a contracts class? Because like if we were doing anything in this dumb class, it would be, this is the law of bargain for exchange. And we now know, economically speaking, this is the law of bargain for exchange. And so what we're doing is if we can have contracts that restrain trade, that reduce the gains that parties get by trade, we would undercut the entire reason for enforcing this stuff in the first place. Literally every contract would make the world worse off. Rather than every contract, at least Pareto efficient contracts, every contract makes the world better off. Right? Okay. So that's why we're treating this under the rule of reason. I want to show you how important the rule of reason is. I know people have gotten fundamentally confused recently about the First Amendment, but let's maybe just take a step back. It is a strong cultural value. It's wild. You go to Europe and they're just like, what's this First Amendment business? You guys are zealots about it. That's very strange. We had people who said very bad things and we needed to stop them from saying those things for historical reasons. And so we don't understand why you let people say whatever they want. That is, it's a cultural value. It's a strong US cultural value. You may think that you are very nuanced about the First Amendment. Go to Europe and you'll suddenly realize everyone's looking at you like you have a horn in the middle of your head, like you've got 4 eyes, like it's just like, what? Because you will seem like a monster to them, no matter where you land on our political spectrum. Real cultural value. Hey, let's replace this contractual provision for one that restricts your freedom of speech. Anybody know what those are called? Non-disclosure agreements. Silicon Valley loves them to death, so much that they call them friend DAs to make them sound warm and fuzzy, right? So yeah, right? And what do you want to bet? Does a court pull out its pen and like start scribbling all over an NDA the way it starts scribbling all over these non-competes? Hell no, absolutely not. Right? The court's just going to be like, did you agree to not talk about it? Now, there's a technical reason why. Let's just, so that I don't make you sad inside and teach you bad law. Why is a contract to not talk about the IP that you're seeing when you go to a Silicon Valley firm? Why is that not a restriction of your First Amendment rights? It may be restricting your free speech, but it's not restricting your First Amendment rights, Jack, because it's between private parties and because the government is not the one telling you to shut up. I used to make the joke that when I was teaching at Indiana University School of Law, I could actually violate your First Amendment rights. But since then, I have been freed and I can't now, so you have been warned, right? I'm not capable of violating your First Amendment rights. I do not work for the government. I work for a private university. Whereas in Indiana, I was technically an official, like I was working for the government. I couldn't violate your free speech rule. Okay, that's technically why. But here's what I wanted to point out about that cultural value. This is why I was making my point about Europe. It's a strong cultural value that people should be able to speak their mind and offer information into the marketplace of ideas. That's a strong shared cultural value. I know we're in a weird moment right now, but go to France, you will find out we are in a very different place as an entire culture. And yet, contracts courts, you agreed to it. Like a boxing match, you agreed to change the rules under which you operate. Under the First Amendment, that gives that strong, broader cultural free speech moment. Fine, courts are just like, you can agree to give that up. You can agree to not say certain things. I just want to show you how strong this public policy in favor dealing with contracts in restraint of trade is. It is, for contract law, stronger than the United States Constitution, which should tell you something. Okay? That's why you just can't go around saying, this contract is doing things that we don't like, because you could do that. You could say, this contract is restraining my ability to speak freely. Important cultural value. You will not win under Restatement 188. Any further questions about contracts in restraint of trade, all pets, what it's doing, 185 through 188? Yeah.
Let's say they were actual they were medical doctors instead of veterinarians.
Yep.
Would they, and let's say this community needed more services, like more doctors, then would they cut out the contract and basically let them?
Yeah, I mean, I think that's true. Look, I can give you no better example than this, and I think I mentioned it before. Virginia is a profoundly conservative judicial state. I don't mean conservative on any political spectrum. I just simply mean they don't love vague rules of contract construction. They want to stick with precedent and what they've already decided. The Virginia Supreme Court basically will toss these things. Like they will just toss them left and right. They're just like, absolutely not. They're basically not worth the paper that they're usually these days not written on. They're not, because of everything that Megan said, because they stop people from being able to practice their profession, because they reduce competition, because they increase costs, and because contracts in restraint of trade are like I don't know, I'm losing my pop culture thoughts because I don't really have that many of them, but they're like the Sith of Star Wars is the only thing I have left in common with you anymore. It's the Sith of the Force, right? It's the opposite of what contracts were meant to be. Like the lightsaber goes red and you're like, okay, I know you're the bad guy. That's how heavy duty contracts in restraint of trade are. They're nega contracts. And so, yeah, for all those reasons, like if the community needs people, if there's more than enough room for everyone to do it, the court's going to start restricting that. It's going to start playing that stretching game. It's going to start saying the area you need is smaller and smaller in order to support the practice. Another practice could really open up over here. We're going to rewrite this to have a smaller and smaller practice. The biggest place where this happened, by the way, was about in 1990, where all these contracts in restraint of trade, these non-competes, ran into the internet. And the courts were like, no, this looks to me like you're not letting a person practice their job anywhere in the country because you're saying they can't do it on the internet anymore. And courts generally said, absolutely not. Like, if there's room for both of you, I am going to play this stretching and shrinking game to limit the size of the market necessary in order to permit there to be competition and provision of services. Because that's what contract law is. All right, any further questions on that, Alpat, before we move on? Puts us a little bit behind, but we will keep going, and I think it's a very, very important one to do. All right, so Safransky versus Dunstan, and I have a couple of people who've asked to come in on these. I want to make sure I've got this right. Tierney, you wanted to lead off on it, and Bailey, you're good with taking opposing counsel? Great, let's take it off. All yours.
Do I just give a case summary, or do you want me to argue?
No. Well, I'll ask you to do that in a minute, but if you would mind setting it up for us, please.
So basically, we had Carla and Jacob who were in a relationship, and Carla found out that she would likely be infertile after chemo. And so they both go to Northwestern regarding creation of pre-embryos, and they had kind of these two main documents. One was a signed informed consent, which part of it said that no use can be made to these embryos without the consent of both partners. And then in the event of breakup, Northwestern will follow the terms of court decree or settlement. And that was with like Northwestern, but they made a big point of saying that they should go talk to legal counsel for any kind of further information and kind of inform themselves on what they were getting into. So there was also these options between having a agreement that would be more of like a donor type agreement versus a co-parent agreement. And the parties chose a co-parent agreement. So that was drafted, and the main kind of purpose of that document was to memorialize their intent and agreement that they both would be established as a legal co-parents of the child, and that they would also attempt at least one in vitro fertilization and pre-embryo transfer cycle. And within that, Jacob agreed that he would take all legal, custodial, and other obligations to the child regardless of any change in circumstance between the parties. He also agreed that all eggs are in Carla's sole control, and if they separate, Carla would also control the disposition of the pre-embryos. However, the agreement was never actually signed. Then they had further appointments. They went through the whole process, and eventually 3 pre-embryos were viable. Then this whole agreement and going to Northwestern was in March of 2010. In May of 2010, Jacob breaks up with her over text. And in August of 2011, Jacob files a pro se complaint seeking to prevent her from using the pre-embryos.
Okay.
So then the court is considering whether the agreement is enforceable on grounds of public policy, or whether contracts relating to sex, family, and procreation lie outside the realm of contract law. It's in Illinois, and it's a case of first impression. So they then go through these kind of 3 options.
That was going to be my first question. Brilliant. What are our 3 options? Well done.
So the 3 options are the contractual approach, which is one of the 2 options that Carla is in favor of. Basically saying that the courts would enforce governing the pre-embryos. They would enforce governing the disposition of pre-embryos, which were entered into at the time of the in vitro fertilization, so long as they don't violate public policy.
enforcing any writings that the parties had. And the big pros of this are that it encourages parties to enter into agreements that would avoid future litigation, and it removes the kind of court involvement into private family decisions. But there's been some criticisms that it insufficiently protects the individual and societal interests at stake and ignores the difficulty in predicting your future response to such a big life change like parenthood. That is the predominant approach in New York, Oregon, Tennessee, Texas, and Washington. The second approach is the contemporaneous mutual consent approach, which is what Jacob is most in favor of, and that would require that both parties have to consent, and that applies whether or not the pre-embryos are like utilized by the initial parties, or if they try to donate them to another patient for research, or to just have them destroyed. And then if the couple can't agree in that situation, they just keep the embryos frozen in storage. The criticism of that is that it's really unrealistic because you're in court to begin with because the parties clearly can't agree. So then you're giving both sides this like really powerful bargaining chip when a lot of them are in divorces or whatever. So you don't want to give them this like power to hold over each other.
And where have we seen that before? Like, we don't want to give one party power at the end of the relationship over the other. At the beginning is fine, but sort of in the duration. Where have we seen that?
I can't think about that.
Sure, let's just invite co-counsel. Anybody got a crack? Yeah.
Was it TNR excavating when they were going through the divorce?
Yeah, a bunch of those. Go ahead.
Last shot rule.
Last shot rule. Like, there's a bunch of these moments where we say, hey, we're not going to let you have discretion to make this deal that we've made where both parties were going to get something into a heads I win, tails you lose. Do you see how contemporaneous consent does that? It makes either party able to just veto it, and they can hold the other party hostage, meaning, by the way, that if that were the rule, would you say that this was a contract at all? Do you see it? Illusoriness everywhere, right? This really would then constitute an agreement to go through with this if we feel like it at a later date, and we would call this essentially an agreement to agree. So you can see some of the contractual objections. So sorry for interrupting your flow, but let's go ahead and get to the third section and kind of where we are with that.
Sure. So the balancing approach is the third and final approach. Carla is also fine with this approach because it involves a lot of compelling interest. For anyone who is found to be unfertile after she goes through chemo, she has ovarian failure, so she cannot have children. So the court uses this to balance interests of the parties, and the court enforces the contracts between the parties as much as they possibly can, and then after that they balance their interests in the absence of an agreement. So resolving disputes over conflicting interests of constitutional import is something that the courts are very familiar with, so they feel like they're prepared to kind of take on that role. But the big criticism is Iowa actually has an issue with this, and they're the only state who uses the previous approach. Anyway, they're saying the balancing approach is an issue because of its internal inconsistency of just each case is so specific to the people, and the court, it would just be very challenging for them to be consistent.
Yeah.
And interestingly, there's like case examples for most of these. This one, Reber is utilized a lot with Carla's side of it, and utilizes this approach because Reber has an almost identical fact pattern and rules in front of or for the kind of Carla part of the case.
Superb. And there's plenty of things to criticize that approach as well. Just to start with, if we have problems balancing how much this is worth to me and worth to you, right? And courts are very uncomfortable coming in and determining that. You can imagine how uncomfortable they are trying to balance this kind of question. So there's a problem of what's called institutional competence. The court's not going to know better than the parties what the value of this kind of huge life step is to them. That's crazy. And then, of course, the other problem, and I love that you flagged it, was the courts are suddenly talking about like constitutional questions in a contracts class. And anytime they do that, you're just like, okay. The court is now profoundly sad inside. Like they are really, really worried because, of course, contract law is the most private law, other than property, I would imagine. It's the most private law of the private law things. Yes, of course, it has huge constitutional implications, but public law is way over here, private law is way over here, and the court's like, I'm reaching. Which way do you want to go on this? So I'm going to ask Bailey to take the other side here in a second.
I would support the contract.
Okay, the strict contractual approach. Now at least we pinned them down. What's your take on the strict contractual approach, and what is your, so you think it should be enforced on the strict contractual approach, right?
Like I have a couple like points on this.
Yeah, fire away.
I think that in the contractual approach, it mentions that if they were like the disposition of the three embryos that were entered at the time of in vitro fertilization, so long as they do not like violate public policy, I would argue that forcing somebody into like a parental situation very much violates public policy.
Right.
And like why you can say that the contemporaneous mutual consent approach definitely puts somebody on the hook. You can say the same thing on that other side by saying, okay, I'm going to make you a parent, and now you have to do these things. The second thing I would say is that in the very end, the court talks about on remand, the circuit court found that they had an oral contract allowing Carly to use the three embryos without Jacob's consent, and then rejected Jacob's assertion of the medical informed consent document modified or contracted their oral contract. A couple different things. I would say one that I'm going to bring in statute of frauds here if we're going to really talk about contracts.
Yeah, like, by the way, I love your point there, right? Does everybody feel the sort of weirdness in the room? Like this is weird, y'all, to be using contract law to do this. By the way, there's weirder law. There's a subtext of law here that's in the backdrop. What's the subtext of law? And nobody wants to say it either. It's constitutional is clearly there, lurking under the surface, although this is a private law class. Yeah. We call that, what class do we teach? Like I'm right over there when I teach it. Property is a weird, like you think, is there a regime that's worse for dealing with human relations than contract? Yeah, that we can do worse. But like not a lot worse, but we can do worse. Like these are so bad, the fit here is so rough. And what I want to do is just highlight, you're like, okay, right? Like, okay, I want to give you full freedom. Like, okay, if we're really going to do this, even though there are express carve-outs all over the law. By the way, where have we seen this express carve-out of the law? You know, for example, that we, obviously for important reasons, we no longer enforce these rules on enslavement. Where do we just see those rules? Today. Non-competes. We do not enforce contracts for personal services. That's called indentured servitudes. That's not a thing, right? What I need you to see is the subtle thread that's underneath all these cases today. There are some things that contract law wasn't meant to do, right? And that's the weirdness that's underneath this whole case. So I am so with you when you say, all right, if we're going to do this.
Yeah. So I would say that like further, there cannot be, I think, an enforceable oral agreement because there was no statute of frauds because I feel like it's definitely over $500.
I need you to feel the tension, right? Can you feel how weird the fit is? Like it's just getting worse. Keep going. I love it. It's definitely over $500, right?
I do very
Oh, all right, by the way, like let's just make this. What law are we under?
I don't want to say it.
Yeah, no, come on.
I think that we might be under the
Yeah, we might be under the, like, I mean, this just gets stupider. Like, do you feel like the weird and the weirder and the weirder? Like, because the embryos are movable. And then you're like, yeah, but then UCC Article 2 only governs goods, which is personal property. Shit, no, this is bad. What I love is the further you're pushing this, the further you're just making the case. This is the wrong classroom, the wrong hat. Everything's wrong. Like I'm wearing the wrong shirt. The whole thing's wrong.
And so then I also, I don't think that it could be completed under 1 year because
Oh, I'm so happy I can't breathe. Keep going.
Because not only is she in this position where she has to complete like chemotherapy, which could take a while, right? But also because like pregnancy itself, like if you start it anywhere past like where 9 months would kind of push you over into December, then you can't. There's
And as long as we're doing that,
I was gonna say about like the year thing, like if it's considered like a good,
wait, there's so many ifs. Like we understand, we're already in like insane land here, right?
produced in under a year.
Yeah, right. Remember that statute of frauds provision? Love that you raised that. Remember that statute of frauds provision requires that limitation only for contracts which by their terms cannot be produced in under a year, and at least it's an arguable thing that there would be a miraculous outcome of chemo, et cetera, right?
I would also argue being a parent is not something you can do in just a year.
Sure, although then,
I mean, the whole point of it, the purpose of it being like the part of the contract that we're talking about. It's not about all of parenthood. It's talking about like
well,
and the pregnancy.
is there an all of parenthood?
Yeah, if the guy gets custody responsibilities, which is like 18 years.
So I mean, I think your statute of frauds argument's looking even better.
And then, okay, so then I have like another further point.
Yeah, go for it. Do it.
So
This is amazing.
I wanted to kind of go back to like the interpretation piece of the contract where it talks about, and I want to talk about like parole evidence. I think that even if we talk about, okay, like the oral agreement for some reason, right? Let's say that like we don't get that whole under year $500, right? Even if the oral contract is the contract, I think that you could still get around like you could shift the lever into saying, oh, the informed consent for assisted reproduction is the actual contract. And like the concept of like consent and consent, like the external evidence for
Something's displeased with us.
there's a question of meaning surrounding consent because it has
Yeah.
informed consent for assisted reproduction, and then later the court says there's an oral contract allowing Carla to use the pre-embryos without Jacob's consent, and then they rejected the medical informed consent document. So
Yeah.
I think that you could definitely submit that and say, oh, well, there's external evidence to
Right.
contradict that term.
Oh man, and there's so much to unpack about that. Let's just make a few points here. We're already all over the show, right? We're like, this is an easily resolved case under the law of property, except absolutely not. And contract is a weird fit. And now we're bringing in a whole other area, informed medical consent. What class are we in? Torts. By the way, anybody watch The Paper Chase? Did they make you do this before you went to law school?
Yeah.
What was the opening case?
The Harry Hand case.
The Harry Hand case, Hawkins versus McGee. We might reference it at the end of this class, not at the beginning of this class, because it's a remedies case. But let me ask you this. How many of y'all have signed a contract with your doctor where the doctor has said, I will do this for you, and you will pay me, and I guarantee you these results, and you guarantee me payment? Like 0 times. It's the weirdest case to have in a contracts book of all time. Informed medical consent brings in the whole law of torts. What I love here is that we're using it though as a contract doctrine, not as a tort, not as best standard of care or negligence in a tort framework, medical malpractice in a tort framework. Here we're saying, no, but those words on the page are considered part of this agreement. Where have we seen before that, in fact, you can staple multiple things together as part of a statute of frauds document? Where have we seen that? Arnold Palmer, the watch case, Certina Midgerobe, right? We've seen this, all of these letter of intent cases where we get real grabby about these different documents, and it's weird to exclude this one. All right, we've got a bunch of different things. What I want to boil these down to, and I love I love both the setup and the response, is to say this is clearly a case for contractual enforcement on the one hand, because the parties came to a clear agreement. If we're using contract doctrine, the more we point out the absurdity of using contract doctrine, the worse the case for enforcement gets, because if we take contract doctrine seriously, there's all these profound inconsistencies that start cropping up in the case, and maybe that leads us to the fundamental uncertainty in the class. Why is the court even considering this in our section of the book on public policy, the weakest of the arguments? What's going on here? Why is this in here? What? Yeah, crazy. It's cheap, right?
Yeah, you just get a contract and then you just, there, done, boom.
So we're done. But why is so that's why the parties did it. Why is the court doing this?
It's because it's, I mean, having a child and like the entire concept of like IVF and everything around that is such like a massive like deal. And like they want to encourage people to have children, but then they also don't want to put people in a position where they have to parent children.
Or they have to parent.
So I think that, of course, I think the court wants to grapple with this as part of public policy because it also emphasizes how much you need something like agreed upon in writing, maybe. Like it just like there's so many different things you have to factor into. And I think the Court of Appeals of New York mentioned something where they're like explicit agreements avoid costly litigation. They are necessary and all the more necessary and desirable in personal matters of reproductive choice. And so, because I mean, the costs of that are incalculable.
So I think we're left with it. Who wins this? Look, on the one hand, I think the parties came to an agreement, and courts are overwhelmingly tempted to enforce those agreements. Two, I think there's been a lot of really great points made. This is just the fit is wrong. And I think this is an important lawyering tip. Sometimes we use the following legal language. This case sounds in tort. That's the language we use. This case sounds in contract. This case sounds in constitutional law or in public law. What does a lawyer mean like that? It means when we got together as a community and we did these classes and we talked about the law and we did some practice and we talked to judges and we just sort of have a sense of smell as a guild where we're just like, yeah, this is good here. This works. These doctrines work here. But I want you to feel the weirdness when we started talking about the UCC. Like that's why one of the reasons why the courts suddenly pushing this into public policy and starting to talk about all these, like it seems to lose the discipline of contract law and starts reaching to constitutional law and importance of reproductive choice, and and sometimes, it's grabbing constitutional doctrines, like the parties agreed on this stuff and we wanted to have that agreed upon up front, and that seems to be really important for these life decisions, for the parties to be able to reach that. But then you're like, yeah, but somebody's being forced to do that important life decision against their will, no matter what rule we use. And it makes this really compelling argument for saying contract is just the wrong classroom for this. It's just not the right framework. I can guarantee you property's the wrong classroom for it. We felt that for a minute. But contract also is just this weird fit, and that's why property law has its in. There's no way a court's going to have this long dark night of the soul about forcing one party to do something that they don't want to do, when the thing they don't want to do is lose their bet against the universe because the price that they got was a bad price on the contract, right? Once we're back in core contract doctrine, the court's going to lose this long dark night of the soul. It's the subject matter about family, reproductive, important choices, and the fact that somebody's going to be forced to do something no matter what. But then how can we plan if we can't have certainty ahead of time? If we use this contemporaneous consent rule, that sounds fantastic, except that means that we don't actually have any kind of agreement. And so we're stuck, and we're fundamentally stuck, I'm convinced, because we're in the wrong classroom. Your mileage may vary. All right, brilliant work. Any further questions on this? These are not rules of general contractual application. This is a description of how weird it gets when courts in one area start applying their doctrine to like something the hell over here. There's no takeaway black letter law from this, other than do not do this. Like, if you can imagine saying to the court, well, no matter what happens, somebody's going to be forced to take a loss on this contract, therefore we should call the whole thing off. I would not take money to make that statement. These are not generalizable rules. You need to understand that the court is doing this in a public policy area, precisely because there's this huge range of different options under public policy. Okay, cool. Let's move on. Very well argued. And we are now going to turn to the big bad. Unconscionability. Annika, would you mind setting up Williams for me? It should come as no surprise, Ben. I'll ask you to take opposing counsel.
Yep. to value of the purchase item, to lease the item to Williams for a stipulated monthly payment. The contract provided that the title would remain in Walker Thomas until the total of all the monthly payments made equal the stated value of the item, at which Walker Thomas could earn the opponent to take title. In the event of default, Walker Thomas could repossess the item. So basically, from there, the consumer defaulted on her payments, Walker Thomas repossessed the items, and then the consumer argued that I didn't understand the contract, basically.
Yeah, that's the part that we're going to need to get into. And actually, I've assigned co-counsel because I have or opposing counsel, but who's also going to be kind of co-counsel because I have a sense you have an understanding of the underlying thing here. What's this, right, so you've worked in the car industry before, is that right?
Yeah, I've worked in a couple terrible industries.
Yeah, okay. I didn't say it was terrible, and in fact, in this case, it's going to be really useful to understand what's going on. So let's settle this out. What is, first of all, the core of this case is a collateralized transaction, right? What's going on? When somebody buys a car,
Yeah, you sign an agreement and say, I'm going to make the payments on this. If I don't, you can have it back.
okay, so I'm going to make the payments on this. If you don't, you can have it back. Now, that's a very kind and gentle way of saying that. What does you can have it back in this context look like when you don't pay for your car? They're going to repossess it, right? This is the law of repossession. Again, I have in the past taught, although not for the past decade, I'm wondering if they don't love me anymore, secured transactions. That's what this is. This is the law of collateralized transactions in personal property. And that's what's going on. This case is mostly a secured transactions case. It's usually where we teach it, but we're doing it here under other circumstances. Okay. What I need you to understand is if you don't pay for the car, they come kicking your door. They don't come kicking your door because that's actually the black letter law of repossession. So you're allowed to repossess without breach of the peace. You're not allowed to kick in the door because that's a breach of the peace, right? Anytime that somebody's going to be standing there with a baseball bat, that counts as a breach of the peace, and you can't do that. Oh, but all that aside, this contract is more than that, though, isn't it? This one's not just if you don't pay for our furniture, we come repossess it. Did you detect the twist in this one that the parties are really having a dark night of the soul about? And I'll open this to co-counsel Scott. Yeah, they're beginning to shift what they can repossess. Marlene. They can repossess all of the furniture. You ever done one like that? No. No. Yeah. Like I don't want to put you in a rough place. I have no idea which way Anique's going to go with this, right? Whether or not she's going to want to say this contract is void for unconscionability. That's where we are. That's the black letter law here, or whether not. But so not to put you in a position, but why not?
Because I didn't have that much control of the terms. First.
One, sure.
But also because I feel like it makes this weird case of like where the contract formed, at what point, and it's also just kind of a piece of crap thing to do.
Yeah, it's weird, isn't it? Oh, yeah. They're combining them all as one. Is that a bar to a collateralization contract?
I was just going to say no one's going to agree to that.
That's where we're going to start with this. No one's going to agree to that. Why? Why is it that if you go buy something on credit from, I don't know, like let's try to pick the Walker Thomas of today, Walmart. If you go to buy something on credit from Walmart, why are you overwhelmingly unlikely to say, hey, in order to buy this new thing from Walmart, like I think the last thing I bought from Walmart, I still have them, right, were the AirPods Pro, and then the new ones came out, and that jack doesn't work even. Just I'm not going to plug for them. Go Bose. So imagine going to do that and buying it on credit, and then them saying, yeah, everything else that you've bought from us stands as collateral for that contract. Man. By the way, did anybody, and I'll open it up to either of our counsel, did you happen to notice how they managed to make that work so that they were not going to just repossess the one thing you got, but they were actually going to come kick in the door and repossess everything you'd ever bought from them. Do you see the provision in that contract? And I know you've already said that like the contract is hard to understand, and I agree. No, seriously, like the right response. Like to get to the bottom of the contract is going to take a real minute. It's hard if you haven't taken a whole other class. So I'm there with you. How did they manage that? To say, I'm not going to just repossess your AirPods Pro, but like I'm going to repossess everything you've ever bought from us before. Do you notice how they did that? Go for it, yeah. Perfect. Describe that in detail. So let's say I owe $100 based on this new thing that I bought, right? And they're going to branch it across everything you've ever bought. And then if I pay them $10, let's say I had $10 remaining on my MacBook Air that I apparently bought at Walmart, right? So let's say I have $10 remaining on that MacBook, and I pay them $10. What are they going to do with that $10? Right, broken up in detail. Kat?
Yeah, I think my understanding on it is that they were intentionally sort of manipulating these payments so that, like I think in the text, one she owed like 3 cents on one object and she bought like 5 years ago, and they were sort of like very, very slowly, incrementally lowering the value of those items, so that way like they retained all control over the items and she didn't own anything at all.
Do you see that? So that if I give you $10, they're like, cool, I'll do $5 to your AirPods, but then I'm going to do like 10 cents to this, 10 cents to that, 10 cents. And they're never going to go below zero. Like it'll be they'll put this at like 0.0001 cent if they have to keep a balance on it so that they can seize everything that they take. Now that is called and this has all been answering your question, like, can we talk about what the hell this contract is? That's called a cross-collateralization clause. A cross-collateralization clause says that when you borrow money for something new, we're going to cross-collateralize it with everything else that you already owe us on.
So can we pay through this and give them a check that says only for the payment of my MacBook?
No, on 2 grounds. One, because the amount you owe on it is liquidated as part of the contract, and Wong versus Peisner doesn't work on liquidated amounts.
But like the check, like they like talk about.
Yeah, and then you would say like, you could say in settlement of all debt, but then the answer to that is they'd be idiots if they cashed it. But like, I like how you're thinking. Strong work. But yeah, there's sort of 2 reasons why that would be rough. One, because there's no uncertainty about the amount you owe. Do you see that? That makes it liquidated. That was Valeria's question about what's liquidated. Liquidated is literally when there is no question about what one party owes. And then the second reason is because they won't cash it if you say it's in settlement only. Cool. Okay, what makes this cross-collateralization clause? Would you sign a cross-collateralization clause? I'd be like, absolutely not. Why? Yeah, it absolutely strips your bargaining power. We're going to come back to that note in a minute. Right, so now you're stuck. They call that in Latin, these cross-collateralization clauses, they put them in for the in terrorem effect, right? For example, the modern high-tech version of this, Williams versus Walker Thomas Furniture is an older case. The high-tech version of this is now if you are in financial distress and you need a car loan and you need a car loan with certain very good terms, you can get it, but they'll put a starter interrupt device on your car. And for one woman, she was on the interstate outside of Las Vegas going about 70 miles an hour when they turned her car off. Right? If you don't make your payments under state law, and under state law, you actually have a lot of time to get your car back. Press of a button, starter interrupt device, and your car gets electronically repossessed. That's where we're going with this stuff. It is some shady ass practices. And that's why it's unconscionable. Anik, what's the law of unconscionability? When will we choose not to enforce a contract because it is unconscionable? Right, so it's unreasonably favorable. we got to give that some content, or like we're just screwed, right? So let's just open this up. Like, can anybody give it some content? Like with that, unreasonably favorable? Holy shit, that's like every contract we've looked at all semester. That's not useful.
Isn't it the whole like no reasonable person would ever?
Give me that language. So we like that we've got the black letter answer, right? But now let's start giving this content. What's this no reasonable?
No conscionable person would ever agree to this. Like it's so out of realm that we would never. Nobody who understood it would ever do it.
Right, and that's called did anybody notice what we call that test? This is the black letter law test for old unconscionability. It is the shocks the conscience test. The shocks the conscience test does follow what Leland said. It's structured in older and gendered language, sometimes expressed as a contract term that no gentleman would offer and no sane person would accept. Something like that. We might say today, no decent human would offer and no sane person would accept. That's our shocks the conscience standard for unconscionability. Now look, I mean, you know, what shocks the conscience? We can try to give it further push. Does getting a bad price, let me give you what's going to be on the bar and on my exam. Does a bad price constitute something that shocks the conscience? No. It does not. It does not shock the conscience. Why does getting a bad price not shock the conscience?
Because courts don't like getting subjective value contracts.
Right, they don't love that at all. And so we then begin to build out a framework that we're going to use for not just old unconscionability, but new unconscionability. And new unconscionability is not in your book. And I'm going to ask somebody in a minute, why is new unconscionability not in your book? And they'll be incredibly happy if somebody's got an answer for it. All right. But we're going to talk about new unconscionability in a minute. This is where we are now. I do want to back this up. Do you want this to be, you want to take the side of this is unconscionable or this is not unconscionable? This is unconscionable. And I think we've sort of explored why. Like, this is unconscionable. This is obviously not unconscionable, right?
Not at all.
Not remotely unconscionable. And let's prove it. Why? Why is this not unconscionable? Yeah, she agreed to it. Yeah. That's one place to say she agreed to it. Let's just bounce roll back. She agreed to it.
I have little knowledge of the terms.
No knowledge of the terms.
No one has any knowledge.
No one has any knowledge of the terms.
But since I had no knowledge of the terms, I really didn't consent to it.
So you didn't really consent to it, Ben? If that's true.
Well, if that's true, then I still get my stuff back because there's no contract and you would have unfair enrichment by having my...
You're right, like if that's true, I get my stuff back anyway, we had no deal, but also, and you haven't paid me, so there's unjust enrichment, et cetera, but also like the internet wouldn't exist, right? Like if we had to say that you had to read these contract terms in order to be bound by them, that's just, not, like, that's not a thing. That flies in the face of Easterbrook. Wait till we get going with Easterbrook. Yes, he is the monster at the end of this particular book. That is where we are going with this particular fight. Go ahead.
I think to support Annika,
yeah.
Her best argument is I have 6 little kids at home.
Oh, absolutely right. Oh, there's no question. And what's that driving here? It's not just that it's not that I didn't consent because I didn't read it. It's that my choice was taken away because... It starts getting into the 6 kids at home argument, yeah. There's significant inequality between the parties, right? One of them is profoundly financially distressed. Lucas?
It's also not much of a choice. Like if you need a washing machine, you need a washing machine.
Okay, there's not much of a choice. This is the driving thing. You need a washing machine. You're not going to get a washing machine. Hey, why does that go against the principle of choice, right? That's what Annika has been saying. Is like she had to agree to this. This violates our basic principle of consent to the contract. Reading it, not a strong argument, but this is much stronger. Why does that? She needs a washing machine. Cool. Where's she going to go to get a washing machine, Lucas?
I mean, she probably doesn't have any other option besides financing it.
Yeah, she doesn't have any option besides financing it. She has to get it, and so therefore she has to go to them. All right? I want everyone to feel this in their bones because we're about to get real brutal with this. The argument is, and let's even spell it out, why does she have to go to them? Why does she have to go to them to get this washing machine? Why don't we just say, this is a free market? Yeah. They're the only ones in her area that provide financing? That's true. Yeah.
They're the only people that will sell it to her despite her low income.
Yeah, why? Both are right. Why?
Because they're seeking to get everything she's bought back from her.
Are they seeking to get everything that she's bought back from her?
She just doesn't have the credit score, like she wouldn't have.
She doesn't have the credit score, so why is she getting a better deal? Why is the only deal in town them? They do want to charge her interest and make more than they could, yeah.
Because this system allows
There.
her to set up collateral basically.
There it is, because she has more collateral with them than anyone else. And the more collateral you offer, what happens to your contract terms? Your interest rate goes down. Seriously, y'all, if somebody asks you for more collateral and raises the interest rate, laugh, then slam the phone down. Right? Like, what the hell? The whole point behind collateral is that it reduces the seller's risk and decreases the interest rate that they have to charge in order to profit from that risk. Oh no, this is not looking great. By the way, who's right? That's not my point. My point is to sort of pack this out. So, okay, you're the only game in town, and her argument is she had no choice, and your response is, like, she had to come to you.
I guess my response would be, yeah, but you're not a very safe bet, and so I need the extra security. So it's either that or higher interest.
Yeah, like the reason that you were forced to come to me is
No one else would be.
no one else is going to do business with you at this rate, especially at the rate that you need. No one else is going to do business with you at this rate. To be clear. Got a response to that? And again, feel free to depart from like law and just be a human for a minute. Like what? Got a response to that saying like no one else is going to do business?
In a way you took advantage of me.
Yeah, right? Like, do you think that's actually how this works out in reality? Like, the same thing's true of payday lending, right? Do we think that provides a needed service? For some people, absolutely. Do we think that it's okay to charge people who are trapped in a cycle of eternal debt 30% per year? No. I'm trying to swear less on camera. Right? So yeah, like the fact that these were the only people who were going to do business with you and that the interest rate could be lower, one, doesn't mean it was lower, and two, doesn't mean that they're not going to use the in terrorem effect. Why do you think car companies use start or interrupt devices?
They can charge lower interest rates because they know they'll get their collateral back immediately.
They can charge lower interest rates to make repossession easier. Is that what they want? Do they want to repossess the car?
I was just gonna say it would like force you to pay.
There it is, because guess what you pay for when your car has a start or interrupt device? I'm going to list a few things. Groceries, medicine for your kids, or your car. Which one? Yeah, right? And now Annika's like, and screw you and the horse you came in on, right? Like, because now you're saying, I've got 6 kids and I'm paying off my TV over my flipping medicine and groceries. Okay, look, like I get the economic argument that I was the only game in town, but maybe one answer to that is that's just not the way the world should work, and we can and must do better. I'll make one last point, because you were involved with like small businesses. Do you happen to know how like businesses make payroll every month?
I guess I don't.
Because you sell cars, right? And did your customers all pay on time?
That was the bank's issue.
Yeah, it was the bank's. Right. No. Oh, I love that answer. That's the bank's issue, not yours. Do you happen to know why it's the bank's issue and not yours?
Because they were the ones who made they had the contract with.
Did they have the contract with?
It's because they're lending to the company to make payroll anyway.
There it is. Every month. Anybody know what that's called? Every month, most businesses are borrowing from their bank to make payroll. It's kind of like electric current, right? It comes in jagged and you want it to come out smooth, right? You want to be able to make payroll in a smooth stream of cash, but your payments coming in are jagged AF. Same deal, by the way. I get paid this way. Y'all don't, like when you go out there in the world, Many of you will pay. Some of you will not. When you open your own practice, you will remember this lecture because some of your clients will pay and some of them will not, and you need to make payroll every month. And so you borrow every month to get that nice smooth stream of payment, right?
You're describing insurance.
I am describing insurance in some respects, but here you're getting this smooth stream of payments. Now, you do have to pay it back, right? What you borrowed. And you can pay that back after your clients pay in jagged amounts. But let's say you don't pay. Anybody want to guess what the terms that you borrowed? This is called a revolving line of credit. It's a monthly line of credit. You have a line of credit. Anyone want to guess how that's structured with your bank? Sure, you're going to pay them back because your clients will pay you. But what if they don't? What does the terms of your loan with that bank say?
Would your interest rate go up? They just repossess your business?
Yeah, they're going to repossess your business. And to be clear, are they going to just repossess things you bought with that bank? No. They will repossess, and this is from a different class, secured transactions, but here's the language. They will repossess all of debtors' property, whether now owned or hereafter acquired. All of debtors' property, whether now owned or hereafter required. That will be your collateral clause. Hey, what's it called when you say, I am now going to repossess all of debtors' property, whether now owned or hereafter required? What do we call that? We call that a cross-beeping collateralization clause. This clause that we've made out to be this utter monstrosity turns out to be the core fundamental unit of running any small business ever. Hey, why do businesses do? We just asked Annika whether she would sign that for TVs and furniture. And answer, absolutely not. We all agreed. Hey, would you sign that clause for running your own small business?
Yeah.
Yeah, absolutely. And what are you getting out of it?
The opportunity to have employees.
To have the opportunity to have employees. That's nice. Why else are you doing it?
Cheap credit.
Cheap credit, because it drives down the interest rate. If you think you can pay it back every month because your business is doing okay, and I'm not saying like brilliant, you're not making $1 trillion, you're just running your own single practice, you hung a shingle out, you figured out how to use AI, you start getting clients, right? You're able to make your payroll on and off and on, like you're doing okay. Great, do this. It reduces your costs of borrowing for a necessary financial tool to keep your business open. And I go, what's the difference between these two pictures? We've now just said this is unconscionable. It does, in fact, this. 6 kids. Medicine not being paid for. Food not being paid for. Fuck, I gotta let you go. Does that shock your conscience? Yeah. Does a cross-collateralization clause in a small business shock your conscience? That's what we got to pick out last time. We're going to end up next time. Thanks for being so kind to let me go over 2 minutes. Appreciate it.